Hello friends, welcome to EPG Pathshala. I am Dr. Paramita Chattaraj from the School of Law, KIIT University. Today I will be discussing about the module Sentencing and Criminal Justice System. The learning objectives are to make the learners understand the significance of sentencing in the criminal justice system, to make the learners understand the different determinants of the sentencing policy, to acquaint the learners with the sentencing process, to acquaint the learners with the relevance of the sentencing guidelines. Now, sentencing is specifically the court's prerogative, and by providing the link between criminal law and the penal system proper, the courts fulfill the key function of relating offences in general to the punishment of particular offenders. The punishment is attached to particular offence depending on the penal policy formulated by the state. The past 30 years have seen enormous changes in the philosophy and practice of sentencing and corrections. The strong emphasis on rehabilitation that exists for the first 7 decades of the 20th century gave way in the 1970s to a focus of fairness and justice, by which sentence reflected just deserts rather than a utilitarian motive. Sentencing practices later moved towards a crime control model that emphasized incarceration as a way to reduce crime in the community. This crime control model became increasingly popular during the 1980s and 1990s. The historical changes in the sentencing and correction policies and practices can be characterized in the part by the emphasis on different goals. 4 major goals are usually attributed to the sentencing process: retribution, rehabilitation, deterrence, and incapacitation. Retribution refers to just deserts. People who break the law deserve to be punishment. The other 3 goals are utilitarian, emphasizing methods to protect the public. They differ, however, in the mechanism expected to provide public safety. Deterrence emphasizes that offenders are deterred from committing crimes because of a rational calculation that the cost of punishment is too great. The punishment is so repugnant that neither the punished offender nor others commit crimes in the future. Incapacitation deprives people of the capacity to commit crimes because they are physically detained in prison. Rehabilitation, on the other hand, attempts to modify offenders' behavior and thinking so they do not continue to commit crimes. Although sentences frequently address several of these goals in practice, the emphasis on which goal is the highest priority has changed dramatically in the past 30 years. At the same time, the goals of punishment have been changing. The number of people in most countries who are under correctional supervision has increased enormously. Changes in the practice and philosophy of sentencing and corrections have clearly had a major impact on incarceration rates. However, there is no consensus on what specifically has caused the changes, the impact of the changes, or the intended and unintended consequences. This paper explores these issues. Now let us first talk about sentencing in the criminal justice system. The broad objectives of the criminal justice system that have been codified through these can be inferred from different statutes, including the Constitution and judicial pronouncement. In March 2003, the Committee on Reforms of Criminal Justice System, a body established by the Ministry of Home Affairs that made comprehensive recommendations of the criminal justice reforms in India. The committee observed, as in every democratic civil society, our criminal justice system is expected to provide the maximum sense of security to the people at large by dealing with crimes and criminals effectively, quickly, and legally. More specifically, the aim is to reduce the level of criminality in society by ensuring maximum detection of reported crimes, conviction of the accused persons without delay, awarding appropriate punishments to the convicted to meet the ends of justice and to prevent recidivism. So, these were the recommendations of the Malimat Committee. The Law Commission in its 47th report says that a proper sentence is a composite of many factors: the nature of offence and the circumstances extenuating or aggravating the offence, the prior criminal record, if any, of the offender, the age of the offender, the professional, social record of the offender, the background of the offender with reference to education, home, life and the mental condition of the offender, the prospective rehabilitation of the offender, the possibility of treatment or training of the offender, the sentence by serving as a deterrent in the community for recurrence of the particular offence. In cases of conviction, the sentence that may be passed is limited by the procedure adopted for the purpose of trial and the limits placed by section 29 of the CRPC or different classes of magistrates. If the case is tried by the Chief Judicial Magistrate or Chief Metropolitan Magistrate, the upper limit of the sentencing would be any sentence authorized by except a sentence of imprisonment for life or for imprisonment for a term exceeding 7 years. A magistrate of the first class or a metropolitan magistrate may pass a sentence for imprisonment for a term not exceeding 3 years or of fine not exceeding rupees 5,000 or of both. All summons cases and a few enumerated warrant cases are triable summarily by all classes of magistrates, including metropolitan magistrates, but not magistrates of the first class unless they are duly empowered, as provided under section 260 of the Criminal Procedure Code. But the sentencing power is restricted under section 262 CRPC to a term of imprisonment not exceeding 3 months. Offenders also have to be classified as a casual offender, an offender who casually commits a crime, an offender who is habitual, a professional offender like a gangster, terrorist or one who belongs to mafia. There should be different kinds of punishment so far as the offenders are concerned. Similarly, in fixing a sentence, many factors are relevant: the nature of offence, the mode of commission of the offence, the utter brutality of the same, depravity of the mind of the man. Sentences contemplated by section 53 of IPC are death, imprisonment for life and forfeiture of property or fine. In the Supreme Court judgment in Sonam versus State of Kerala 2013 volume 11 SCC 3821, the court cited a number of principles that it has taken into account while exercising discretion in sentencing, such as proportionality, deterrence and rehabilitation. As part of the proportionality analysis, mitigating and aggravating factors should also be considered. The court noted in State of MP versus Bablu Nath, the Supreme Court stated that the principle governing imposition of punishment would depend upon the facts and circumstances of each case. An offence which affects the morale of the society should be severely dealt with, as held in State of MP versus Bablu Nath, 2009 volume 2 SCC 272. Let us now talk about death penalty. Death penalty is awarded under the Indian Penal Code for treason, murder and after a horrific gang rape in 2013 in the capital city of India saw a overhauling of certain provisions relating to the offence against women. The legislature through amendment provided capital punishment for certain extreme forms of rape, like rape which either causes the victim to be in a persistent vegetative state or death, or repeat sexual offences. There are many who support death penalty in India. For instance, there was huge demand from the general public to impose death penalty in severe forms of rape and murder cases and also mass killings in terrorist attacks. Further, section 354 clause 3 of the Code of Criminal Procedure provides that the court, in case of awarding the death penalty, must give special reasons for such sentence. The constitutional validity of death penalty under the Indian Penal Code was considered by a constitutional bench, that is 5-judge bench of the Supreme Court in Bachchan Singh versus State of Punjab, AIR 1982, Supreme Court 1325, and by a majority of 4 judges held that in case of conviction of murder, life imprisonment is the rule and death sentence is an exception, save in the rarest of rare cases. In Machi Singh versus State of Punjab, AIR 1983, Supreme Court 957, the Supreme Court elaborated as to what constitutes rarest of rare cases. And after a balance sheet of aggravating and mitigating factors are drawn out and full weightage is given to the mitigating factor and still the court comes to the opinion that there is something so uncommon about the crime which renders a sentence of life imprisonment inadequate and therefore calls for death penalty. The Supreme Court further observed in Lehna versus State of Haryana 2002 volume 3 SCC 76, the rarest of rare cases are such when the collective conscience of the community is so shocked in circumstances such as murder that are extremely brutal, grotesque, diabolical, revolting or dastardly. Murder with such motive which evinces total depravity and meanness, for example, murder by hired assassin for money, murder of individuals belonging to minority caste or bride burning, or murder of wife to remarry after adulterous affair, multiple murders of entire family or community or locality, murder of a child or helpless woman or old or infirm person upon breaching the trust or respect that the victims had on the perpetrator. Now, what is the concept of life imprisonment under the Indian laws? The Constitution Bench of the Supreme Court in Gopal Vinayak Godse versus State of Maharashtra, AIR 1961, Supreme Court 600, Ashok Kumar versus Union of India 1991 held that the sentence of imprisonment for life is not for any definite period, and the imprisonment for life must prima facie be treated as imprisonment for the whole of the remaining period of the convict's person's natural life. In light of the legal position that even though the law provides for imprisonment for the full lifetime, the government may commute the sentence after 14 or 20 years, the Supreme Court has begun a new trend of imposing mandatory sentence, as in Haru Ghosh versus State of West Bengal, JT 2009, Volume 11, Supreme Court 240. The trend that has also emerged is to give a direction by the sentencing court or appellate courts confirming such life term, to give a direction that the convict would not be released from prison for the rest of his life, as in Swami Shraddhananda versus State of Karnataka 2008, Volume 13, SCC 767. In 2013, the Criminal Law Amendment Act, while providing for life imprisonment under Section 376A, D and E for certain extreme cases of rapes, provided as part of the substantive provisions that life imprisonment means for the remainder of the natural life of the person. In Indian laws, so far as the other custodial punishment are concerned, there are certain offences for which maximum term is provided and also provisions for mandatory minimum punishment. For instance, Section 397, 398, 376, 376A to E of the Indian Penal Code, and also certain offences under the Prevention of Corruption Act, NDPS Act, the Protection of Child from Sexual Offences Act, etc., provide for mandatory minimum punishments. Some of these offences are offences against society as a whole, against public health, against the safety or well-being of society at large. Such punishments are based on utilitarian principles of deterrence and incapacitation. With regard to non-custodial sentencing, the earlier penological approach held imprisonment, that is custodial measures, to be the only way to curb crime. But the modern penological approach has ushered in a new form of sentencing, whereby needs of the community are balanced with the best interest of the accused. Verbal sanctions such as admonition under Section 3 of the Probation of Offenders Act 1958 or reprimand may be appropriate for young offenders, enabling them to realize that they have done wrong without being stigmatized as criminals. Economic penalties such as fines, but offenders with little money may have difficulty in paying them. Therefore, community service emerged. Community service as a form of restitution that benefits the community rather than the individual victim and has the advantage of making demands on the offender and at the same time producing a useful outcome in the form of the work done for the community. Various supervision measures can also be imposed on the offender and can of course be adapted to the needs of individual offenders, helping them to reintegrate into the society. Section 361 of the CRPC makes it mandatory for the judge to declare the reasons for not awarding the benefit of probation. In 1958, the legislature enacted the Probation of Offenders Act, which lays down for probation officers to be appointed who would be responsible to give a pre-sentence report to the magistrate and also supervise the accused during the period of his probation. Both the Act and Section 360 of the Code exclude the application of the Code where the Act is applied. The Code also give way to state legislation wherever they have been enacted. Such a release on probation may be permissible only if the following conditions are satisfied. Number 1, there is no previous conviction proved against the offender. Number 2, when the person convicted is a woman of a age or any male person under 21 years of age and the offence of which he or she is convicted is not punishable with death or imprisonment for life. Number 3, when the person convicted is not under section 21 years of age and the offence of which he is convicted is punishable with fine only or imprisonment for a term of 7 years or less. Now, what kind of sentencing policy does the Code follow? Sentencing policies provide the means to hold offenders accountable and reduce the likelihood that they will commit new crimes. Protecting the public is the key objective of sentencing, and state laws provide guidance on which offenders should receive prison terms and how long and which offenders are suitable for community service or other alternatives. Legislatures provide courts, corrections departments and parole boards with a set of sentencing options and sanctions for offenders. They also set requirements for offenders' assessment to guide appropriate placements. To ensure that sentencing policies are most effectively protecting the public, legislatures can review certain crime classifications, enhance sentencing options, and consider time served requirements and release policies also. The sentencing policy can be based on two broad models, that is, first, the justice model of sentencing and correction, a process of determining sentences according to fair, just sentencing policy. The model is based on retributive notions of deserved punishment. The sentence should be fit for the crime. Under the model, offenders would receive their just deserts, nothing more, nothing less. Advocates of the justice model argued that neither people nor prisons should be used to achieve the public end, such as rehabilitation. Instead, punishment should be proportionate to the crime, not a means to achieve a utilitarian motive such as rehabilitation or crime control. The only relevant factor to consider when sentencing an offender would be the crime of conviction and the offender's criminal history. Individualized treatment and discretion would be eliminated, and the criminal justice system would treat all offenders similarly. The justice model carried with it direct implications for public policy. For example, the model held that offenders should be given substantial procedural protections at all stages of the criminal justice process. Thus, the legal rights of inmates became of great importance for the courts and corrections. Rehabilitation, if used, should be voluntary. The largest policy impact grew from the need to change from indeterminate sentencing to determinate or flat sentencing. Under determinate sentencing, a specific crime would carry a clearly identified sentencing length, not a broad minimum and maximum. Parole releases would be eliminated. Sentence length would be determined by guidelines that considered only the offender's current and past criminal activity. The second model could be the crime control model. While proponents of the justice model argued for abandoning the rehabilitation model, others began to argue for increased crime control through incapacitation and deterrence. Escalating crime rates from 1965 to 1975 in the United States led law and order advocates to attack rehabilitation as coddling criminals. They wanted to implement policies that would limit the ability of judges and correctional officials to mitigate criminal sanctions and advocate get tough proposals for mandatory minimum sentences and lengthy determinate sentences. The concept of incapacitation is simple. As long as the offenders are incarcerated, they cannot commit crimes outside of the prison. Interest in incapacitation as a crime prevention strategy grew during the mid-1970s in part due to concerns about the efficacy of rehabilitation raised by the Martinson report, using crime rates and public fear of crime. Let us now talk about judicial discretion to sentence. Now, judicial discretion to sentence is quite wide for judges in India, whereas in other jurisdictions like USA and UK, the sentencing discretion is modulated by the sentencing guidelines. Where the law provides only an absolute penalty, of course, no room remains for discretion. All the court can do is evade legislative barriers by applying a legal provision which it should not have applied. For example, by accepting a plea to a lesser charge. Having a sentencing policy means, however, not merely using one's discretion, but using it in the specific and consistent manner with some ultimate object in view. Focused on the individual offender, this object of sentencing aims first at the most appropriate sentence, primarily reached at by drawing a balance sheet of aggravating and mitigating factors for each of his offences taken in isolation. Second, at the most appropriate treatment, whatever it may be, for the whole of his criminal activities, stretching perhaps over the larger part of his life. Focused on the criminal population as a whole, the concept of a sentencing policy means that there should be a consistent correlation of whatever kind may be between the treatment allotted to one offender and that allotted to others. Now, how does the sentencing process works? For most offences, the judge applies its discretion within the range of minimum and maximum punishment. Factors that influence sentencing have been clearly settled by a series of court pronouncements. For instance, the rarest of rare principle in Bachchan Singh and Machi Singh with regard to imposition of death penalty. For imposing substantial punishment, many aspects in the form of aggravating factors are taken into account. Similarly, for reducing the quantum, factors which mitigate are also taken into account. Therefore, in the sentencing process, both these factors are taken together. Eminis in his On Sentencing lists out various factors under the head of seriousness of offence, which are the key concept. Several subheads indicate when the seriousness of offence is aggravated, where the victim is especially vulnerable, that is, where the offender takes advantage of a helpless person, a very young or very old or handicapped person. He also speaks of breach of trust. This arises in a case where somebody takes advantage of a person who is interested in his career or a person who abuses his office. A premeditated crime executed with professionalism also is an aggravation. Excessive violence, offences by a group or an offence committed by persons on bail for a particular crime which is prevalent in an area and causes public concerns are all cited as aggravating factors. He also lists factors which mitigate the seriousness of offences. Offences committed under grave provocation, offender acting in circumstances though they may not amount to defence to decide culpability. Other factors listed by him are young age of the offender, old age of the offender, offender's previous character, clean record where the offender has performed meritorious service, where the offender shows remorse, offender pleading guilty, serious illness of the offender, effect of sentence on the family, passage of time after the offence has been committed, also germinate and the extenuating factors. These are some of the criteria or guidelines according to Eminis which will have to weigh with a judge who passes the sentence. Another important aspect of sentencing is the concept of sentencing guidelines. The Indian Penal Code prescribed offences and punishment for the same, but many offences only has maximum punishment, and for some offences the minimum may be prescribed. The judge has wide discretion in awarding the sentence within the statutory limits. There is now no guidance to the judge in regard to selecting the most appropriate sentence given the circumstances of each case. Each judge exercises discretion according to his own judgment, and there is therefore no uniformity. Some judges are lenient and some judges are harsh. Exercise of unguided discretion is not good even if it is the judge that exercises the discretion. In some countries, guidance regarding sentencing option is given in the penal code and sentencing guideline laws. Currently, India does not have structured sentencing guidelines that have been issued either by the legislature or the judiciary at present like in other jurisdiction of USA and UK. Therefore, judges in India have more sentencing discretion than in countries with sentencing guidelines. The Malimat Committee also emphasized the need to introduce sentencing guidelines in order to minimize uncertainty in awarding sentences. In 2008, the Supreme Court of India in the case of State of Punjab versus Prem Sagar and others 2008 volume 7 SCC 3501 also noted the absence of judiciary driven guidelines in Indian criminal justice system, stating in our judicial system we have not been able to develop legal principles as regards sentencing. The superior courts, except for making observations with regard to the purport and object for which punishment is imposed upon an offender, had not issued any guidelines. The court stated that the superior courts have come across a large number of cases that show anomalies as regards the policy of sentencing. Adding, whereas the quantum of punishment for commission of a similar type of offence varies from minimum to maximum even where the same sentence is imposed, the principles applied are found to be different. Similar discrepancies have been noticed in regard to imposition of fines also. In 2013, the Supreme Court in the case of Somam versus State of Kerala 2013 volume 11 SCC 3821 also observed the absence of structured guidelines. However, in describing India's sentencing approach, the court has also asserted that the impossibility of laying down standards is at the very core of the criminal law as administered in India, which invests the judges with a very wide discretion in the matter of fixing the degree of punishment. As observed in Jagmohan Singh versus State of Uttar Pradesh 1973 volume 2 SCR 541, sentencing procedure is established under the Code of Criminal Procedure, which provides broad discretionary sentencing powers to judges under section 235, 248, 325, 360 and 361 of the Code of Criminal Procedure. In a 2007 paper on the need for sentencing policy in India, author R. Nirupama asserted that in the absence of an adequate sentencing policy or guidelines, it comes down to the judges to decide which factors to take into account and which factors to ignore. Moreover, he considers that broad discretion opens the sentencing process to abuse and allows personal prejudices of the judges to influence decisions. Now, to summarize the above discussion, in absence of any sentencing statistics made available by the government, it is indeed difficult to ascertain the sentencing structure that is actually existing in India. However, different research work conducted on the aspect of sentencing point towards an inconsistent and randomized sentencing, possibly owing to the wide unguided discretion on the sentencing judges. Giving punishment to the wrongdoer is at the heart of the criminal justice delivery system, but in our country it is the weakest part of the administration of criminal justice administration. Administration of criminal justice. There are no legislative or judicially laid down guidelines to assist the trial court in meting out the just punishment to the accused facing trial before it, after he is held guilty of the charges. Therefore, the need of the hour is to formulate a comprehensive sentencing scheme or guideline in tune with the peculiarities pertaining to the Indian society and in general the criminal justice system, in particular for bringing in a structured sentencing, so that an appropriate response to crime does not remain a dead letter, but also is seen to be done. Thank you.